So there have been some major developments in a lawsuit that aims to overturn state bans on the purchase and possession of suppressors. And what just came out of this case could impact suppressor laws across the entire country. Today, we're going to break down exactly what happened, what the court ruled, and why this matters for the Second Amendment moving forward. Chapter 1. What this case is about. Two separate lawsuits, Morse v. Raoul and Anderson v. Raoul, were combined into one major challenge against Illinois' total ban on suppressors. While most states allow the ownership of suppressors, there are still 9 jurisdictions that prohibit them outright. This case could be the first to strike down one of those bans as unconstitutional. But a few days ago, the district court threw the entire case out in favor of the state of Illinois. The court claimed that suppressors are not protected arms under the Second Amendment, and therefore the plaintiffs failed to state a valid constitutional claim. The plaintiffs have already appealed the case, and it's now heading to the Seventh Circuit Court of Appeals. Chapter 2. What the plaintiffs argued. The plaintiffs based their arguments on the Supreme Court's ruling in NYSRPA v. Bruin. Under Bruin, the government, not the citizen, has the burden of proving that a firearm restriction is rooted in history and tradition. They argued, the Second Amendment doesn't apply only to weapons from the 1700s. Just like the First Amendment covers modern forms of communication, the Second Amendment covers modern arms. Suppressors are tools that improve safe firearm operation and therefore fall under the protection of arms. According to them, technology evolves, and the rights evolve with it. Chapter 3. What the state argued. Illinois responded by saying, suppressors didn't exist at the time of the founding. There's no historical tradition of devices designed to reduce firearm sound. Therefore, suppressors are not arms, but merely accessories. The court ultimately agreed with the state. Chapter 4. The court's ruling. The district court adopted a new interpretation of Bruin that no other court has applied this way before. The judge said, a modern device is only protected by the Second Amendment if a similar version existed in early American history. Since suppressors don't have a historical analog, they fall outside the meaning of arms. Suppressors are accessories, not weapons. The court even acknowledged that some attachments, like sights or magazines, might be protected because older versions existed historically. But suppressors, the court said, have no 1791-era equivalent. Because of this, the court dismissed the case entirely. Chapter 5. Why this is a big problem. This type of analysis is alarming. If courts require a historical precursor for every modern firearm component, then red dots, weapon lights, many magazines, modern materials, even certain firearm models could be considered unprotected simply because they didn't exist in 1791. This is a direction the Supreme Court did not outline in Bruin, but this lower court used it anyway. Chapter 6. What happens next? The plaintiffs have appealed to the Seventh Circuit Court of Appeals, making this the most advanced suppressor ban challenge currently in the court system. There are other suppressor cases in New York, New Jersey, and California, but those are still in early state, and whatever the Seventh Circuit decides could influence every other suppressor lawsuit in the country. Attorneys from other states are already pointing to this ruling as justification for their own bans. This appeal will be critical. We will be keeping a close eye on this case because it has major implications for suppressor laws nationwide and for how courts interpret the Second Amendment under Bruin going forward. If you found this breakdown helpful, make sure to like, comment, and subscribe. And stay tuned. More updates will be coming as soon as new information drops.